That was the tail end of the prosecution's closing argument, not the rebuttal, but the actual closing argument, the first crack that the prosecution gets at closings in the Tex McIver murder case. If you've been following us for the last several weeks, you know we've been covering that case intensely. The case of an Atlanta attorney charged with murder and a number of other charges, including witness tampering, related to the death of that defendant's wife, who was a CEO, Diane McIver. She was the victim. Now, the defendant has said pretty much all along that this was an accidental shooting, that he had his finger somehow on the trigger, but he was drifting in and out of sleep. The car stopped or hit a bump, and that the gun went off, and the barrel just happened to be pointed towards his wife. The defense has stuck with that, has poked a lot of reasonable doubt holes into the state's case in chief, at least in the opinions of most of us who are sitting around the table here and analyzing the case around the country. So, and we will continue to break this down. The jury still has the case. They've been on the clock for 3 days officially, even though the first day was just a little bit more than an hour and a half of deliberation. To help us break it down, Julie Rendelman, Law and Crime trial analyst, is here. Julie, we had another euphemism, an analogy there in the tail end of the tail end of the closing argument there from the state about the pollen. And they're trying to say, well, you know, if pollen falls on a car, then it's reasonable to conclude without doubt that there's just a lot of pollen in the air, that nobody came by with a spray gun and sprayed down everybody's car in the parking lot or the garage or wherever they keep them. I mean, is that euphemism helpful for explaining what reasonable doubt really is?
No, because I couldn't follow it. So,
you couldn't.
So
it's okay.
I guess if I, maybe I'm.
So what caused the pollen? If you walk out and you see pollen on your car, if you've been down south, you know that this stuff is in the air a lot thicker than it is in the Northeast here. So you walk out, there's pollen on your car. How did the pollen get there?
Right.
Because the trees are flowering, or because somebody walked by with a spray gun?
Is that more an issue of circumstantial evidence, or is that an issue of reasonable doubt?
I don't know. You tell me, former prosecutor.
I'm not sure. I didn't follow. Look, I was more surprised. I'm always surprised when prosecutors and defense attorneys talk about personal things going on, because I don't think that's proper. And many times the opposite side will usually object, because you're not supposed to include even the most simplest of things that relate to anything you're doing. The evidence is the evidence. And so, I understand she's trying to personalize herself, and the at-you was lovely and enjoyable, but I'm not sure how it was relevant to anything in regards to this case, nor do I think it's admissible.
Well, ultimately what she's trying to get across is this, okay, look, you can take a piece of evidence, and then you might have doubts about how that evidence got to the position where it was discovered, but are they reasonable doubts? And she's trying to say, okay, look, you can sit here with anything. How did the pen get on the table? Did I leave it here? Did Jesse Weber leave it here? Did the Tooth Fairy leave it here? Well, what's the most reasonable reason that the pen is on my notepad? That's because I put it there. And she's trying to get the jury to say, look at the most reasonable explanation for the evidence, and to ignore the doubts.
I think that's just a horrible, I'm not really seeing that analogy as helpful to the jury. I'm not, so,
You think it fell apart. Okay, fair enough.
And you didn't? You like that analogy? Or that?
I mean, I think that listening to the way that she explained it, I think that it made some degree of sense, and trying to explain to the jurors. I also think that, unfortunately, and I think we all know from anyone who watches this, there is probably a level of bias from my perspective. And when I say bias, I don't think I'm being fair to myself. I've watched the evidence along with everybody else. And so so if you play it out the way she describes, you're left with reasonable doubt. And so I guess when I look at kind of her way of having the jury view kind of what they should perceive as what reasonable doubt is, I'm like, at the end of the day, that's not helpful to the prosecution. And so I view it as not helpful to her in going down that road. Well, we're going to continue marching through our analysis of some of these statements in the Tex McIver case. We're going to go. Well, we're going to continue to analyze, but the judge, I'm being told, while I speak, is back on the bench in the Tex McIver case. So we're going to get prepared to jump back into the courtroom live. The last thing we heard from the judge about 10 minutes ago was some logistical discussions about how to get members of the jury into the vehicle where this shooting happened, because they asked to bring the actual gun into the actual vehicle. So this may be a continuation of some of those discussions. Let's listen to the judge. More logistics questions in the Tex McIver courtroom. The judge dropping another hint there as to what the jurors are talking about and what they want the court to do. So we heard a number of questions from the jury yesterday. One of them was this one. They wanted to take the actual gun used in the shooting and bring it into the actual gun where that shot rang out. Again, the defense says that this was an accident. The state is trying to say this was intentional murder, that it likely was planned. Big difference in theories of this case. It's a question of how to characterize facts. Members of the jury want to get the gun in the vehicle, and now, just seconds ago, we learned from the statement from the judge, I hope you caught it, the jurors want to get in there and recline the seat the way the seat was reclined in the photos that were taken of the back of that SUV. These are the photos that the crime scene investigators took. And apparently, when the jurors saw the SUV this last time, when they saw it the first time in the case as the case was moving on, the seat was in some kind of a different position. They want to get in there, Julie, it seems, with the gun. They want to sit in the seat. They want to try to line up this trajectory themselves. They want to figure out whether this looks like a deliberate shot or whether this looks like an accidental shot. They want that seat reclined back exactly the way it was during, allegedly,
sure,
the actual shooting. Now, as a threshold inquiry, does this indicate that jurors are just not trusting the analysts who went through this and did it themselves? It's almost like they want to dismiss the trajectory rods and the 3D models and all of these other pieces of evidence. They want to get in there and see if this makes sense themselves.
I don't know if they're rejecting what the experts say. They're trying to analyze themselves in their own mind and compare what they see with what the experts say. And keep in mind, because remember, we had several questions that were asked by the jury, including one that intimated that many of them may have already determined he's not guilty on the top counts. So when we start to go back into the vehicle and kind of want to replay what happened, you have to remember that this may not be all the jurors that are curious. It may be one or two that want to do that replay to either confirm that they believe he's guilty or they believe he's not guilty. The concern always is when you get back into the vehicle, if you're getting back in there, you're not the exact size as Tex McIver, you're not the exact size as Diane McIver, you don't get the positions exactly right, then whatever your version of in replaying this event is not going to be accurate. And that's a danger that the judge has to consider whether he's going to even let them back into that car.
Well, it seems like he's going to let them back into it in some fashion. It's just
yes,
a question of how far they're going to be able to go with this. Because,
right,
okay, you know, how did the seat get reclined? Was the seat reclined when the shot was fired, or was it reclined when Tex was reaching forward to try to apply some care to his wife who had been struck by the bullet? You know, I mean, or are they going to try to figure that out? And this is the thing, when the jurors just go this far down the chain of doing their own experiments, are they going to start reading things in that were not actually placed into evidence?
I agree with you.
Does that become an appeals issue, that they're doing their own experiment that's not subject to cross-examination? Do we have a confrontation clause issue?
I don't know if it's an exact confrontation clause issue, but if
I would say it was if I was the defense.
Look, it's one thing to want to analyze, you know, the evidence that came in before you. You know, many judges, by the way, don't even allow jurors to handle guns in these type of cases. They only allow one of the court officers to handle it. You know, so, you know, here we have a situation where they've arguably letting them to make a determination as to how much pull it takes or power it takes to pull the trigger on that gun. We're going a whole extra step now because keep in mind, if you recall, the prosecution brought in a fake model that was supposed to be almost identical to what the vehicle was, which was, you know, they even had, if I recall, Diane McIver sitting in that vehicle, in that made-up vehicle. So I'm not sure why that can't be enough, arguably, for the jury to use that as their model.
And then there's been a lot of debate about this 3D model that we're looking at right now. You know, how exactly was the gun being held? The state has got its version of things, and then Tex McIver said in an interrogation that this was not exactly how he was holding the weapon.
Right.
And, you know, the jury might want to try to figure that out, too. You know, does Tex McIver's version of this make sense, or does the state's version of it make more sense? I think it's interesting that the defendant says in an interrogation that his hands are in a certain position, and then when the state makes a 3D model, that's not the way the defendant's hands are shown in the 3D model.
Right, I agree. I think the problem has always been that Tex McIver is Tex McIver's problem, which is that he spoke when he shouldn't have spoken. And I think that in many ways he may not really even remember exactly what happened. If you accept his story to be true, he was just waking up from sleep when the gun went off. And so if that's the case, he wouldn't have remembered exactly how he was handling it.
Yeah, exactly. Okay, you also have Danny Jo Carter's version of this, and she's showing the hands in a certain position. Well,
right.
She didn't see the hands until
she was
after
driving.
The shot was fired. So it's like the shot could have been fired, that the hand could have moved.
Not only did she not see it when it was fired, she didn't realize initially that she had been shot.
So you got one Mississippi's, two Mississippi's,
exactly.
a few more Mississippi's in there before she turns around, she takes a look at it. Well, in that period of time, his hand, it startled him.
Right.
He snapped to it. You know, how is that indicative of the way the gun was positioned when the shot was fired? I think that the trajectory rod's going to tell the true story on that.
Again, I think you probably have jurors. Look, I'm guessing, but I'm willing to bet you have jurors that think like we do, that think, I don't need to do trajectory or anything. There's no way, based on the evidence that we have before us, that he intentionally shot her in the circumstances we described, where Danny Jo was driving the car and out of nowhere he decided to pull the trigger on his wife of his loving wife of however many years. But I do think that there's jurors, I'm willing to bet you, that are just not sure which way to go. And they're the ones that are asking these questions, and they're the ones that are wanting to get in there. Remember, there may be some jurors that want to get in there to prove to another juror that it happened the way they thought it happened. So
I'm sure
we don't
that's
know
going
what
on.
There's a lot going on, but I think that we can't ignore the fact that they did ask that initial question about, coming down to the not guilty to the I think the fifth count.
Yes, the
and
first
that means
question
someone
yesterday.
is thinking that.
Someone is thinking that the letter of the law has not been proven beyond a reasonable doubt in this case. That's what it seems like. And look, I mean, I look at this and say, okay, look, you can think Tex McIver is a sleazeball. You can have all kinds of negative opinions about the guy. That's character. That's not probative of whether this letter of this law was met in this case beyond a reasonable doubt. And if it's not, then he's got to be acquitted. I mean, that's just the way that the system logically works.
Right.
And again, if you missed it yesterday, folks, one of the big questions from the jurors that came out right before they broke for the day is, can we find Tex McIver not guilty on count 1, count 2, count 3, and count 4, but convict him on the fifth count? The fifth count is the only remaining influencing a witness charge that's left. So at least somebody on a jury wants to know if this is at least legally, theoretically possible. And of course, the answer is yes.
And there's a tendency to believe that it's not one juror. That question is, look.
But it's at least one.
We're guessing. We know it's at least one. But when you start asking that question, you tend to believe, if that question's being written, that there's more than one person that believes potentially that they don't have enough evidence with regards to the first four. Again, I'm guessing, but that's my tendency based on that specific question. Again, though, we have the additional questions that were asked, which is, can we see the video of Tex McIver's interview? Mm-hmm. And then also, can we see the emails?
Can we see the emails?
Which would, go against what we're talking about. But again, it indicates that there are one, if not more, individuals believing that he's not guilty of those top counts.
Well, look, I think that this jury is focusing on the critical issues here. I think the jury is seeing through some of the state's other insinuations. They're not asking about the masseuse. They saw through that, I think. The insinuation that McIver was in some kind of an inappropriate relationship with a masseuse. I think that they saw through that.
I hope so. I think you're making several assumptions because, remember, the masseuse is different than this type of evidence. You don't really need to rehear what the masseuse had to say. She said she didn't have a sexual relationship with this individual, and so there's not really that much evidence that contradicts
look, why did they
it.
threw that in there? Because they wanted to try to discolor this guy and make him look sleazy, and then people are like, oh, well,
I understand, but if a jury's going to buy that he is guilty of this crime, then they're arguably going to buy. The way to buy it is to buy that he had a relationship outside, to buy that he had a monetary reason to kill her. And so you have to, I have to say that, I understand motive is not required, but in order to buy that he intentionally shot his wife in that vehicle in the circumstances we're describing, I think you really do have to buy that he had the motives that the prosecutor described. Because without those motives, I don't think you have the case.
We're standing by for a new picture. I'm not sure how quick we can bring this up. We're going to try to get it as quick as we can, but there was a photo taken of the way the car was set up when members of the jury were able to get a look at it. And look, this was a picture taken by a deputy during the jury view. There it is. So this is the way the car was set up when members of the jury actually personally went outside the courtroom and looked at it during the course of this several-week-long trial. Now, Julie, if we compare the way that seat is set up to the picture that was taken by the crime scene tech right after the shooting, here the seat is pretty much straight up, and in the other pictures, which we were showing you a couple of minutes ago, that seat is back. So how was the gun? I mean, that's going to influence where the gun was. Was the gun like this, or was it down and facing upward? And how the seat was reclined is going to be very indicative of that.
It can be. I mean, and again, keeping in mind that whoever sits in that seat, if they're 6'3" and Tex McIver is 5'10", there's going to be a difference with how your hand is holding the gun. You know, like, you know, and the size of the individual in the front of the seat. Again, also keep in mind, on top of everything, we don't know the position that he didn't know the position Diane McIver was sitting at the time that the shot was fired. So all these things come into play that can't exist right now for the jury to evaluate.
Well, I'm glad that we got that picture up, because this indicates what they might be zeroing in on. If that seat was reclined back, then the gun could have been in a lower position, could have been on his lap when he was asleep. And if the trajectory was up further, then it could have been a more deliberate
shot. But Aaron,
shot.
you're making a lot of assumptions, and so
I don't think I'm making a lot of assumptions. They want to know what did the bullet go through the seat like this, or did it come from a lower angle?
But that's not what their question was. Their question was, can we go into the vehicle with the gun? And so you're assuming that the basis of which they want to go into the vehicle with the gun.
Well, no, they said they want to be able to have the seat positioned the way it was in the initial photos. That they want to be able to recline the seat.
I understand, but you're taking that leap, which the prosecution took, which is to assume exactly what it is they're looking for. And that's the thing. Like, by the way, I don't know what they're looking for. None of us know specifically what they're looking for. We don't know if it's all of them looking for it or not. But I think that I understand it may just be simple enough to say, could he even fit his legs in with the gun there to allow him to fire the shot? I don't know. I don't know if it's the whole trajectory thing or not. That's just all I'm saying.
Well, considering that the state made a lot of noise about that during the rebuttal, my guess is that they might be wanting to zero in on it. But I want to keep listening to some of the testimony in the case here as we march along. We are in the midst of the lunch hour in the Florida case that we're covering, the triple murder. We are waiting for a potential verdict whenever it comes in the Tex McIver case. Never know when this jury's going to wrap up. They're probably going to get another look at the vehicle, though, so probably not any time in the immediate future, but who knows? They could take a look at that vehicle and come back with a verdict later today. Never know. We will certainly warn you when we hear that there is a verdict. So let's listen to some more of the closing arguments from the state, and we'll be back with more analysis in a moment. Okay, more of the state's closing argument. The closing argument in chief, indeed, not the rebuttal, but the closing argument in chief in the Tex McIver case. Let's talk a little bit about trial strategy here. So, Julie, this is following a pattern we've seen in other cases. The closing argument, a little bit more methodical, a little bit more about the law, a little bit more about logic, just sort of like overarching principles, a few references to a couple of pieces of evidence and how they would fit in. That was the closing itself. Relatively short, maybe about 45 minutes. Well, then the defense goes, and then when the state comes back with a rebuttal, it's supposed to be a rebuttal, but the rebuttal is kind of the real closing. And that's what we saw in this case. A lot more fiery, a lot more passion, a lot more persuasion, at least from the theatrics standpoint, than the actual closing argument. Now, why is that?
Well, first of all, in New York, we can't do that. So in New York, the fire has to come out initially, you know, because you don't have that second chance, at least in state court, than you do like in a situation like this. What's the reason is because you're the last person speaking. So if you're the last person speaking, you want the jury to remember. And so you want to convince the jury any way you can to kind of obey or follow what you're saying. And so you don't want to leave them with the fire of what the defense says. You want to leave them with what you said. And so, yeah, it's important for... I think it's important for a closing to have, even if you're doing it twice, meaning going and then doing it on rebuttal, I think it's important on both to make clear that the evidence you are being fiery about clearly indicates that he has broken the law in the various ways. And so you have to be careful not to go too far afield of covering the law, so that the jury understands why you're saying what you're saying and why you're so passionate about what you're saying. So that's what I think we're happening here.
I mean, what's the right balance? You're a former prosecutor. What's the balance between doing a really passionate closing and doing one that's more logical and saying, okay, this is what we need to prove to you, this is what the law says, and these are the facts that plug in to prove the point that we have to make to you?
That's such a hard question, because I think that there's no real easy answer. I think it depends on A, the nature of the crime that you're talking about. B, it depends on the nature of the jury that you're speaking to. C, it depends on who the judge is. There's so many factors that come in to making a decision as to how to play to a jury, because every jury is different and every case is different. So you're surely not going to argue passionately, or you're going to argue passionately in all your cases, but you have to be careful. For example, if the victim in a case is elderly, you want to be careful not to besmirch that elderly individual, or you're going to turn off the jury. And so in a case like this, I think we all kind of are sitting here saying, well, if we don't buy what the prosecutor is selling, do they really want to be so aggressive, or do they want to be more methodical to get the jury to kind of get on their side if they're not already? But I think there's no easy answer, because I think every case is different. And quite honestly, every prosecutor is different. Some can pull off passion, some can't.
Well said. Let's continue with our review in the Tex McIver case of the prosecution's closing arguments. That was the conclusion of the prosecution closing argument, not the rebuttal, the closing argument itself. So, Julie, what do you think? I mean, how do you take the way that this prosecutor went about things from a presentation standpoint versus the rebuttal that was, look, more entertaining because it was a lot more colorful, but did the prosecutor on rebuttal oversell the case and risk losing credibility?
Well, I mean, the argument I think that people have had throughout this case is that the prosecutors oversold their case throughout. So if the jury hasn't bought it throughout the trial, then it's not likely they're going to buy it now. I happen to like the prosecutor that did the initial closing argument.
The woman we just watched.
Yes, yes. I do. I think I understand that you should be passionate, and I understand that she's probably a little more standoffish. And so perhaps she could have been a little more, and I think that she could have put more of the facts in to support each of the elements that we're talking about, so to make it more clear for the jury. But I do think that she has a great style, and she might be the style I think that one might need in a case like this, to be a little more methodical.
It's not as clear-cut.
Right, and to explain calmly to the jury why those pieces that me and you may disagree with are pieces that fit in terms of proving him guilty beyond a reasonable doubt. So I think she did a nice job. There's always an issue when it comes to presenting a case to a jury when you have more than one attorney presenting the case, whether it be the prosecution or the defense. And so some people think that it's better to go with one prosecutor and one defense attorney. Why? Because that one prosecutor is the one that arguably builds the relationship with the jury, and so the jury comes to believe in that prosecutor, or sometimes not believe in that prosecutor. And so sometimes people think it's better to have that one person that the jury can trust. So when you start to bring two personalities into things, sometimes it even can throw off the jury in terms of their views.
A side issue here. I was thinking about this. You tell me whether you think I'm insane or sane.
You are insane.
I know you were going to say that. Okay. I left myself wide open. Right. Anyway, okay, so
but other than that,
one of the theories that's been floated about this case, because we're sitting here saying, was the case overcharged?
Right.
Okay. It started down here, and then the prosecutors ratcheted it all the way up to a murder case.
Right.
And it happened after Tex McIver allegedly asked one of his buddies to kind of, like, so-called interfere in it. That's one version of it. Another version of it is to try to cop some kind of a deal or do something.
Right.
Okay, there's been a couple of different euphemisms used to describe what happened. But if the prosecutor ratcheted the thing all the way up to murder to sort of come out of this thing looking more clean, in other words, that I am not going soft on Tex McIver, even though he wants me to go soft on him, is there a ethical risk in approaching it that way if you are the prosecutor?
I don't think that there's an ethical risk, because how do you prove that that's the basis of which the prosecutor went forward? You know, you're making an assumption. I understand that
this is something that has spun locally.
Right, but I think that you'd have to be able to prove that the basis that they went forward is because of exactly what you described. And I think short of a memo that says we're going to go forward because we don't want to look in front of the people of Atlanta that we're going easy on him because he's a popular guy, and so we're going to go for it even though we don't think we have the evidence. Short of that, there's no real dilemma that exists. Obviously,
well, and surely the judge
obviously, as a prosecutor, if you're going forward with a case that you don't believe in, or that you don't believe that the evidence you have makes it out to the jury, then there might be some questions. A lot of times, keep in mind that the prosecutor may say, I think there's enough, I'm not sure. Let the jury decide. And that's okay to do, because, you know, that's the purpose of having a jury, to make that decision. But if you're going in going, I know I don't have it, but I'm just
Well, that would be a clear issue, because then you'd be mischaracterizing the case. Or look, you're making a decision under the rules of conduct. The prosecutor has a duty as a minister of justice, not just as someone to win for a client. It's a different duty. It's a little bit different. And the rules state as such. But look, a prosecutor also has to clear the probable cause hurdle with the judge, and in this case, that did indeed happen.
Well, yeah, I agree with you, but I think that the problem we look at is when you're looking at, for example, the financial aspect. You know, if you remember when we started this case, it opened. After opening, the first witnesses were the prosecution's individuals that were testifying in regards to the problems financially that Tex McIver had. And when you went forward further into the defense case, it seemed clear that they weren't accurate in regards to him having financial problems. And so as a prosecutor, sometimes you wonder, did they not know that there was evidence that really supported that Tex McIver was not as down and out as they had initially stated? Because if they did, then one would think, well, they had an obligation to present that. Or did they not believe that the evidence that showed he wasn't financially down and out was true? You know, so things like that, you start to say, you know, you do have to do your job as a prosecutor. You're not just looking for that of which helps you. You're supposed to be looking for that of which helps you and hurts you, because you want to make sure that you're presenting a fair and honest case to the jury.
And with really complex financial situations, it can be characterized one way or the next. I mean, some people incur debt in certain areas to offset gains in other areas, and then in the end they come out owning a lot more than they would have.
Exactly, which means they're not in debt. So, you know, you can't just take a piece of his financial history. You have to look at the whole thing. And so, yeah, you start to go, well, did they not know about it? You know, so there's questions that come up. I don't think that's an ethical dilemma. Perhaps it's just, you know, sometimes prosecutors and defense attorneys kind of have narrow minds in regards to what they're looking for, and they believe that this is their case, and they're not willing to look forward.
Or if we're to give them a little bit more of a benefit of a doubt, it may just be that this prosecutor's office is not used to digging into things that smell more like finances.
Well, that would not be giving them the benefit of the doubt. That would be actually incredibly insulting to them, that they don't know how to do their job. Because if they don't know how to do their job, then they should not be presenting this case.
Most murder people are used to lining up gun trajectories and bullets and things.
Then you bring in a financial analyst that can explain it to you. I mean,
well, that's what they did.
But I understand that, but the argument you're saying, but the financial analyst missed something, because even by the way, on the direct case, when we were listening, we were like, I'm still missing where his financial problems are. So even on the prosecution's theory, they still seem to be lacking that motive that we talked about, because we were talking about that from the get-go. And so something seemed unclear about that motive regarding the financial problems.
In some ways, I don't think the defense cleaned it up all the way, but we're going to march along with our review of the closing arguments. Tex McIver, Atlanta attorney, facing murder charges, facing aggravated assault charges, facing weapons charges, facing witness tampering charges. The jury has had the case. The deliberations are in their third day. The jurors want to get a look at the car. That's going to happen as the afternoon progresses. We're closely monitoring that situation. We are also closely monitoring the courtroom in Florida, where there is a triple murder trial being tried. That jury is on lunch. While we wait for these cases to march along, let's continue our review of closing arguments in the Tex McIver case. This is the defense. We are continuing to cover live from Florida a triple murder case where an undocumented immigrant is the one who is in the defendant's chair. This is his second trial because in the first case, a witness slipped out the defendant's immigration status. The judge called a mistrial, and here we are listening to the case again. The accusations are that the defendant killed 3 members of his family, one of whom was pregnant, so there's an additional charge for the death of the unborn child. Julie, we are in the midst here of the Brian Hyde case. Correct to call a mistrial after the first one based on the comment of the immigration status? What do you think?
Absolutely, and I think unfortunately in this day and age even more important to do that because I think there's such controversy that comes around the issue of an individual's immigration status as it applies to crime. And we know that in the political arena that it's become such a big issue.
So here we are, we've got murder charges, second-degree murder charges, not first-degree. So that's kind of interesting in Florida. Do you think that the immigration status might be plugging into the way that the charges are being pressed in this? Because, look, Florida usually goes for the death penalty in cases where they think that they can get there. They're not light on the death penalty in Florida. But if they did that, they'd risk this person being in the process for years and years and years and years pending appeals, rather than doing a second-degree murder conviction, which could then result in a deportation.
Right.
Do you think that that's the ultimate strategy here to line this defendant up for that?
I don't know. You know, it is interesting, and remember, the issue with deportation is the question of whether he's going to, if he is found guilty, if he's going to serve his time first and then be deported, or is he going to be deported right away? You know, and there's mixed feelings about that because, you know, some don't want to have to, you know, even like from a financial standpoint, they don't want someone to have to serve the time and they're paying for them to be serving the time when they could be deported and never to return to the country. So it can be, it certainly could be a factor, although I don't know what weighed into the decision as to whether to seek death.
We've got another witness just took the stand in the Hyde case, but we want to switch to the McIver case because the judge is back on the bench there. I want to listen to what the McIver judge is saying. More logistical discussions in the Tex McIver courtroom as to exactly what jurors will be able to do with the weapon, the car. They've been asking since yesterday to be able to take the weapon to the car. And they also want the seat adjusted to match the way the seat was lined up in the first pictures that were taken of the vehicle by a crime scene tech. So, bottom line, here's the judge's way of handling this. They will be able to take the weapon down to the vehicle. They will not be able to talk to one another. They will not be able to have any unsupervised discussions in that area. Bottom line is the judge wants to protect the sanctity of the jurors' deliberations. That's a key part of this. The defendant and the attorneys will be able to be present for it, and the deputy will also be able to be present for the safety of the weapon. Let's listen back to the judge. Yet another version of this question for the judge and the litigants here as to exactly how many jurors get to sit in the car and how far they're able to go with this. Now, one wants to be in the driver's seat, one wants to be in the back passenger seat. They want to recreate this whole thing and try to figure out what it was like from multiple perspectives. And Julie, I'm wondering, is it going to help them even if they can do that?
Well, it depends on what they're looking for. I mean, you know, the jurors, it's up to whatever particular juror's perspective is as to what they're looking for. Again, I'm not sure what they're looking for. I mean, you know, they want to basically recreate the events that occurred. I'm getting a little nervous now in terms of what the judge is allowing them to do in terms of, you know, the questions of, one of the questions was, can they move the seat to the position that the seat was?
Okay, we're going to go back and listen to some of the discussions about this next issue that just popped up. Jurors on their way apparently now to take a look at the vehicle with the weapon and to be able to position themselves in some ways but not others in trying to make sense of the Tex McIver case. But part of me wonders, Julie, at what point do we say, okay, the state has the burden to prove all this to the jurors. The jurors seem to want to get into all these investigatory roles to try to prove something to themselves. Is this conflicting with the burden that the state has to try to prove this beyond a reasonable doubt?
I'm not sure. You know, I think at this stage there's some judges that just wouldn't allow them to go into the vehicle. I don't even think the vehicle is in evidence, so I'm not sure that they would even permit them to go in. You know, the evidence, again, we had a a structure that was made for the jury to use potentially if they wanted to take some position in to make a determination. I get very, as I said before, I think it's very, the concern is that the jury, when they go into the car, are not recreating the exact scenario that occurred when the three individuals that were involved in this incident, the positions that they existed in. And when that happens, the jury is starting to look at evidence that's not really in evidence. And so that's the concern I have with them trying to recreate something that arguably is not recreatable using the individuals that and the scenario they're trying to use.
Possible issue for appeal. Curious to see how this goes. So next issue that popped up on Twitter, I want to show this to everybody. This came out from a local reporter. According to that reporter's sources, billboard companies plan to post this tribute to the victim, Diane McIver, over the next few days across metro Atlanta, her longtime friend tells me. That's the word from one of the local reporters. Julie, members of the jury could be driving home from the case and seeing this. They've been told to avoid watching the news. That's relatively easy. Okay, unplug the TV when I come home. Don't read the newspaper. Don't bring me the newspaper. Don't jump on the computer. How does the jury avoid a billboard that's staring them in the face if they go down the highway?
I mean, they can't, and quite honestly, it says over the next few days. I don't know if their intention is to wait until a verdict comes back to do this.
It doesn't sound like it.
Well, I mean, it says the next few days, so I mean, we'd be guessing if, right now the assumption is that we're going to have a verdict any day now. If they do, I think the defense is going to have a lot of issues for appeal because there's no way to avoid the media if you have a billboard literally in your face telling you this. Now, granted,
and again, it doesn't say convict.
It doesn't say anything derogatory against Tex McIver, but there is sympathy that that exists when you have this large memorial to this woman, and so I do think it can potentially have an impact on the jurors because there is a sympathy aspect to any case, and you don't want that to be something that allows the jury to make that decision. I'm betting you it's not going to come up until the case is finished.
Okay, the other thing is, so look, this company that Diane McIver was CEO of was either involved in managing billboard properties or was tied into a company that did it. So this is sort of her business.
Right.
And, one can view that a couple of different ways. If her colleagues truly want to memorialize her in some way, is that what they're trying to do, or are they trying to kind of like send a subliminal message here that jurors need to be looking out for Diane, not judging whether Tex is guilty of the crime as charged?
Well, I mean, who knows? And the thing is, keep in mind that the jurors are not allowed to look on social media, so arguably they wouldn't even know the potential that this billboard is going to be created and put out there. So as of now, they're not going to know about it. If I was the prosecution and the defense, I would go to the judge and say, let's make sure this doesn't happen until the jury's finished. Because as a prosecutor, I don't want it out there because I don't want to screw it up if there's a conviction and then there's some issue of appeal. And as the defense, I don't want it up there because I don't want the jury to be swayed in any way by this billboard.
And then we're wrangling into that whole area, or wading, I should say, into that whole area of, can the judge, under the First Amendment, put some thumb on free speech, its prior restraint, how far can it go?
Well, it is interesting because I don't know who's doing it. Is it one of the potential witnesses that testified that's involved with the making of this billboard? Because it is someone that used to work with
coworkers.
I don't know. And so he may have some control over an individual that testified. I don't know. It seems like a foolish move to distract an already very lengthy trial. To have it come down to some issue of a billboard would be quite a shame.
Yeah, well, this will be interesting. So we already have had one issue where the jurors, when they were in the process of being selected, were exposed to news coverage of the case in the jury bus.
Right.
That happened so many weeks ago, but then now you might have this. Now you might have this. So look, we're going to keep an eye on the Tex McIver courtroom. Deliberations there moving forward with this jury view of the vehicle in the midst of deliberations, which is interesting to say the least. But meantime, we have this triple murder trial going on in Florida. Testimony there has been marching along. So let's cut back to that case. Well, this is interesting. The defense counsel said that she wanted to bring a picture of something up to the judge and show him along with the prosecutor, Mr. Rucker. And we heard that quick phrase, is it already all over the internet? I'm wondering, Julie, is this the billboard that might be hitting the outdoor advertising areas of greater Atlanta that was tweeted out about an hour ago by one of the local reporters? Yeah,
my impression is that she's probably using the photo that we saw. I don't think it's already out there as a billboard yet. I think she's just probably, showing what we know already and bringing it to the court's attention, because this can be a big problem if the jury's still deliberating.
Yeah, I want to hear what the judge has to say about this one. Well, I can only guess. It looked like the judge was still talking, but for whatever reason, we can't hear it. If there's a billboard like this, can the judge do anything about it? Because then you get into an area of censorship and prior restraint, and I really would have to dust off my knowledge of that area as to whether or not a judge can tell a billboard company who lost an executive. That's the tweet that went out earlier. I'm assuming this is what they might be talking about, right, unless there's something worse out there on the internet. But look, I mean, if I were the defense, I'd be objecting to the possibility of this, or I would at least be flagging the court and saying, hey, look, we got to figure out how to deal with this.
Look, the judge can also sequester the jury if he wants at this
could.
Point, or, control their routes. I mean, there's judges that will say you cannot go anywhere near the scene of a crime. He can also say you cannot go anywhere near where these billboards are. And so he can do it that way, short of preventing the billboards from going up. I assume, again, that I'm hoping that the individuals involved with the creating of these billboards and the placing of them are smart enough to recognize they don't want to screw with this trial, or maybe they do, which is one of the issues that you brought up.
Look, I mean, we know that many of her colleagues were witnesses in this. We know that the company that she was involved with leading was either directly involved in managing outdoor advertising properties or tied into a company that did it. There was a bit of a complex structure there. So, look, I mean, is this colleagues just trying to remember her? And if that's the case, why not remember her after the verdict, not before it?
But by the way, I hate to say that we're relying on hearsay. This is a tweet that comes from someone who spoke to someone who indicated that in the next few days they're putting out this billboard. Mm-hmm. There's no clear indication that anyone has said exactly when they plan to do it, or if they had said they plan to do it once the trial is over and done with. So we're just making assumptions that that's what they plan to do.
Well, yes, certainly. But look, I mean, the time for the defense to speak about this is now, not after the billboard goes up and they realize
absolutely.
All the jurors have gone down the highway.
I think the defense is absolutely right to bring it up right now. I think you're absolutely, but I think we're assuming too much to assume that the intention of the individuals that are putting up the billboard is to A, influence the jury, and B, to put it up while the jury is still deliberating. Because keep in mind, if they wanted to do that, they would have done it weeks ago. This trial's been going on forever, so they would have put it up weeks ago. They seem to be waiting, and I don't think they're waiting because they're worried that the jury's not coming back with the right verdict. Keep in mind, even the witnesses that testified that were close to Diane McIver, not everyone took the side that Tex McIver was guilty of a crime. Some of them relayed information, a lot of them relayed information that indicated that Tex and his wife had a very loving relationship. So there's no assumption to be made that there's some evil doing in trying to put up this billboard, other than trying to express in the remembrance of a loved one.
Yeah, well, if that is indeed what was brought up there, and I suspect strongly that it was, this will become even more and more and more interesting. The dangers of a high-profile trial. Now, usually the dangers involve whether the police are being a little bit too loose-lipped, whether an attorney is being a little bit too loose-lipped. But in this case, when you have a victim who was involved as a career with an outdoor advertising company, apparently there are other issues that need to be accounted as well. So we are going to continue to monitor the Tex McIver courtroom. Again, the jury deliberating the fate of an attorney facing murder charges, facing weapons charges, facing assault charges, facing witness intimidation, witness tampering rather, charges related to the death of his CEO wife. The defendant says it's an accident. The jury's had the case now going on. This is the third day. We will wait and see if there is indeed a verdict. You never know when it could come. While we do that, we continue to listen to the Brian Hyde case out of Florida, a triple murder case involving an undocumented immigrant We've just had a DNA analyst on the stand. She is still on the stand, indeed, saying basically, look, the defendant's DNA is all over rape kits taken from the victims. The victim's DNA is all over the defendant's shoes. This sounds like a pretty slam dunk case for the state, but they have to prove it beyond a reasonable doubt. Let's listen.